Laws, welcome to episode 4. This is a discussion of chapter 4 of UAE Crypto Litigation, available at www.uaecryptolitigation.com. Welcome back. So you sent over chapter 4, and today we're doing a deep dive into something pretty fundamental in the digital asset world, right? We're looking at how UAE law tackles, well, a basic commercial nightmare scenario. What happens when someone takes your capital, promising digital investment, and then poof, they just don't return the principal when it's time?
Exactly. And what's really interesting here, and the source material makes this clear, is that this specific problem isn't really about how volatile crypto is or market risks. No, the focus is purely on the basics, contractual promises. We're looking squarely at restitution, just giving the original money back. And in cases like the one we'll discuss, this lets the court sidestep all the complicated arguments about whether crypto is a commodity or a security or something else entirely.
Okay. So cutting through the noise, we're going to unpack a key Dubai court judgment first, one that showed some real legal efficiency by focusing on core civil law, not the crypto tech specifics. And then we'll look at how today's regulatory shields in the UAE, especially for licensed virtual asset service providers, are actually built to stop this kind of thing happening in the first place. Okay, let's jump into that judicial analysis. We're talking about a significant 2021 judgment from the Dubai Court of First Instance. The facts seem pretty straightforward, but critical. What exactly went down?
Well, the facts were quite clear. You had a claimant who handed over a significant sum, a multi-thousand dirham amount, to a defendant company. And the evidence showed this capital came with a very clear instruction to invest it in the field of digital currencies. So a straightforward mandate establishing a duty.
Okay, so the duty was clear. But wait, the court called it an investment contract. Why didn't they get stuck trying to define the digital currency itself? Wasn't that a huge rabbit hole they managed to avoid?
That's precisely the pragmatic genius of the court's approach here. They didn't need to classify the asset. Why? Because the core of the dispute was about a failure of duty, the duty to manage the capital and provide access, not about whether the investment itself performed well or poorly.
Right. It wasn't about market loss. It was about the service provider just not fulfilling their end. Now, the evidence part is really interesting, especially for 2021. How did they prove things? No paper ledgers here, I assume.
Exactly. And this is crucial. The court actually accepted the defendant's own digital records, things like account data, statements pulled directly from their electronic trading application. And importantly, the court explicitly stated these proprietary digital records had the same evidentiary weight as traditional commercial books under the law.
Wow. Okay, that is a huge takeaway.
Yeah.
So the UAE court didn't get lost in debates about blockchain authenticity or digital forensics back then. They essentially said, look, you run your business on this software, then it's your ledger, and we can use it as proof.
Precisely. It meant the core facts weren't really in dispute, thanks to the defendant's own data. So the court could move quickly to identify the breaches.
And what were those key breaches, the failures that really sealed the defendant's liability?
There were two critical ones. First, the company shut down the electronic trading application. That fundamentally broke the service promise. Second, and this was the clincher, they failed to return the principal capital when the arrangement effectively ended. This showed a clear violation of the initial agreement and trust.
Okay, clear violation established, and the court's response was to terminate, or the term used was Faskh, the contract, which basically means unwinding it, right? What legal principle kicks in then?
Yes, Faskh triggers a cornerstone principle of civil law, Restitutio in integrum. It sounds complex, but it just means putting both parties back in the exact financial position they were in before the contract even started. So that led directly to the order for the defendant to return the full principal sum, the original capital. Restitution.
Got it. So the claimant gets their original investment back, plus the standard legal interest from when they filed the lawsuit. The key point being, because the service provider fundamentally failed their duty, they had to return the capital. End of story. The fate of the underlying crypto didn't even factor in.
Exactly. The focus was purely on making the claimant whole regarding the initial capital entrusted because of the breach, not on untangling investment performance. For more details on this specific case, remember, a copy of the book UAE Crypto Litigation is available at www.uaecryptolitigation.com.
Right. So the court showed that basic contract law works, even in this new digital context. But that was reactive, fixing the problem after it happened. What about prevention? If this exact scenario occurred today, with the mature regulations we now have, How would a licensed VASP be stopped from doing this?
Well, today's system changes the game entirely. A licensed virtual asset service provider, a VASP, operating under regulators like VAR in Dubai or the federal SCA, is basically forced by the rules to have structural safeguards from day one.
Okay, let's break that down. Client money rules first. In the 2021 case, the money was just given to the company. Unregulated, that money probably got mixed with the company's own funds, right?
Yeah.
How do VAR rules stop that commingling?
They put up a very strong shield. The VAR Compliance and Risk Rulebook for 2025 is crystal clear. Client money does not belong to the VASP. It must go into a dedicated client account, usually within 1 business day. But here's the critical legal lock. The VASP must get a written acknowledgement from the bank holding that account, and this letter confirms the bank has no right of set-off against those funds.
Right, of set-off. Remind us, that means if the VASP owes the bank money, the bank can't dip into the client account to pay itself back.
Exactly. That piece of paper legally isolates the client capital. It stops the VASP and its bank from treating client money as operational cash. It protects it even if the VASP itself goes bust.
Okay, that handles the fiat money side. What about the actual crypto assets once they're bought? How do regulators make sure my crypto isn't being mixed up with others, or worse, used by the VASP for its own purposes?
That's covered by strict segregation and custody rules. VIR, for instance, insists on what's effectively one client, one wallet segregation. Your digital assets have to be kept identifiably separate. And crucially, something called rehypothecation, that's where a provider might use your assets as collateral for their own borrowing, is totally forbidden for VASPs under these rules.
Okay, so clear separation, clear prohibition on using client assets. Makes sense. But back to the core failure in the 2021 case. The platform just shutting down, no money back. How does the current regime force an orderly exit, even if a VASP fails?
This is another fundamental shift. VAR mandates that every single licensed VASP must create, maintain, and get regulatory approval for a detailed wind-down plan. This isn't optional, it's a licensing requirement. And that plan must spell out the internal controls and procedures for the safekeeping and prompt onward transferring of clients' virtual assets, including returning virtual assets to clients.
So they have to plan for failure. They have to pre-engineer the process for giving assets back before they even start operating.
Precisely. It forces them to think through the technical and legal steps for restitution from the outset. So if the scenario from the 2021 case happened today with a licensed VASP, failing to return capital wouldn't just be a contract breach, it would be a major regulatory failure, likely triggering that pre-approved wind-down plan.
Right. It elevates the stakes considerably. It moves from a civil dispute risk to a serious regulatory compliance issue, a breach of license conduct.
Absolutely. It's a completely different framework of accountability.
Okay, moving towards prevention now. The court, in the 2021 case, inferred it was an investment contract, which worked, but it's a bit vague. For big players, institutional investors, they want zero ambiguity. How do they build that structural certainty from the contract level?
You're right. Sophisticated players want precision. They use the contract itself to build the legal reality they need. So instead of a vague instruction to invest, they'd use a formal investment management agreement, or IMA. This document clearly establishes an agency relationship. The VASP is formally acting as the client's agent, with clearly defined duties of care, performance benchmarks, reporting requirements. This raises the bar for assessing any potential breach way beyond just, did you give the principal back?
So that clarifies the relationship and the duties. Now, how do they contractually ring-fence the assets? How do they avoid that risk we saw in the original case where the assets could get caught up if the provider becomes insolvent?
The gold standard tool here is usually a tripartite account control agreement, or ACA. Think of it as having 3 parties involved: the client, the service provider, sometimes called the grantor, and a neutral third-party custodian or depository.
Okay, 3 parties. How does that structure protect the assets?
The ACA sets up specific rules. Crucially, it includes triggers. For example, if the service provider defaults or files for bankruptcy or some other agreed trigger event occurs, the client, or perhaps a secured lender if financing is involved, can issue what's called a notice of sole control to the custodian. The moment that notice is received, the custodian stops taking any instructions from the troubled service provider regarding the assets in the account. Control effectively shifts away from the provider. This legally shields the client's property, ensuring it doesn't get swept into the service provider's assets during bankruptcy or liquidation. It's like a contractual emergency brake that isolates the assets.
Ah, okay, so the control mechanism is built right into the agreement, ensuring the assets remain accessible to the client even if the provider collapses. Makes sense.
Hmm.
Lastly, evidence. The 2021 court was okay with the defendant's internal records, but sophisticated parties probably want something more. Objective, right, unchallengeable proof.
Absolutely. They don't want to rely on anyone's internal books. So their agreements mandate a very specific confirmation protocol. For instance, the contract might define that a digital asset transaction is only legally considered settled and completed once it's confirmed on the relevant public blockchain and, say, 6 subsequent blocks have been added.
That's clever. You're tying the legal fact of settlement directly to the public, immutable blockchain record itself. It takes it completely out of the hands of any single party's internal system.
Exactly. It creates an objective, non-repudiable proof of the transaction status that doesn't depend on trusting anyone's ledger. Sometimes escrow agreements are also used to place assets with a neutral third party from the start, adding another layer of control. So when you combine these things, a precisely defined legal relationship like agency, structural asset control through things like ACAs and custodians, and objective blockchain-based evidentiary standards, you get a really robust framework for managing risk in these digital asset transactions. This case really illustrates the straightforward application, a fundamental contract law breach and restitution to a dispute involving digital assets where the evidence was, thankfully, quite clear. And while the court pragmatically called it a simple investment contract, the analysis shows that even these newer commercial activities, they're still subject to established legal principles. However, the current, more developed regulatory regime really elevates things. It takes these kinds of transactions out of the realm of informal agreements and into licensed conduct, governed by specific tech-savvy rules under bodies like the SCA. These regulations clarify the duties of service providers, especially around safeguarding client assets, using robust tech governance and clear protocols. Now, the dispute we discussed centered on a failure to return principal. That made the exact legal nature of the deal, well, secondary to the basic fact of the breach. But disputes get much more complex when they involve capital loss due to market volatility rather than just non-restitution. In those situations, the legal nature of the underlying relationship, how the deal was structured, becomes absolutely paramount. And actually, the next chapter explores exactly this complexity. It looks at a dispute where the court had to decide if a relationship was a loan or a partnership, and that distinction determined who bore the risk and the ultimate financial outcome.
That brings us to the end of our discussion on Chapter 4. This chapter's structure, looking at a case, the regulations, and then preventative contracts, is the standard methodology used throughout the book.
Authored by Mahmoud Aboursel and drawing on analysis from over 100 judgments, UAE Crypto Litigation serves as an indispensable resource for anyone involved in the digital asset industry here.
To read the full analysis for this chapter and to explore the complete 7-part life cycle of a commercial dispute covered in the book, please visit www.uaecryptolitigation.com.
And just a reminder, the discussion in this podcast is for educational and informational purposes only. It doesn't constitute professional advice or create any professional relationship. Please consult with a qualified professional for advice tailored to your specific situation.